Good morning, good morning. Wednesday, 10 a.m. Mountain Daylight Time. As always, that means that we're back with another episode of the Canadian Immigration Live Q&A. It's all three of us today. So Mark just returned from his little trip. Alicia, good to see you again. We skipped last week because I didn't feel well and I was really overwhelmed with the number of files that I had to work on. How are you guys doing? It's been a while.
Good. Yeah, I'm happy to be back. That's for sure.
Mm-hmm.
Yeah, had a great trip down to the States with my wife. It was kind of our 30th anniversary trip, and we did a lot of different things. So it was really fun and really refreshing. But I'm excited to be back in the grind and yeah, just be here to help support our clients through these dark days of immigration.
Right. Alicia, what about you?
Yeah, I'm doing all right. I think there's been a number of consults recently, so people are, they maybe have received an ITA and they're thinking about, well, do I proceed with that ITA? Because they realize when they start going back to their employers that, oh, maybe I picked the wrong knock, or, the employers said that I was working this many hours and my pay stubs say this, and maybe I don't have documents to show my prior work experience before I came to Canada and foreign work experience. And can I proceed? Is that misrepresentation if I've claimed something different in the past on different applications? So I've had a lot of consults recently with people who are really trying to struggle through, do I actually proceed because my work permit's ending? And there's a lot of spouses where, maybe the principal applicant can go on and get that PGWP, but now with the new rules on spousal open work permits, maybe the spouse can't work anymore.
Mm-hmm. Yeah. What do you guys think about the new round of invitation for healthcare occupation? So we had 2,500 invitations issued, and the CRS was 472, which is 2 points more than um, it was back in August.
Yeah.
Yeah, I mean, I think 272 is it's still high, but it's attainable for people if they have healthcare experience. I think it's important that if you are claiming healthcare experience, be really certain that you have a targeted occupation experience, right? Don't try to shoehorn some experience that maybe is characterized better as something else into a healthcare occupation just in order to get the benefit of that healthcare draw, because for sure that's going to be misrep. So be really careful about what your work experience truly is.
Yeah. And it's really interesting how it all comes together, considering that in Alberta they decided to lay off a number of healthcare professionals, and same with the education category, right? Like we don't know how it all plays all together essentially. Now that we have the strike that is third week,
Third
probably.
week.
Yeah, crazy,
Yeah.
crazy. Do you guys envision that things will change when they announce the new immigration levels plan? And if things will change, how
Well,
they will
and yeah, and this was the article I sent to our group chat
Mhm.
because there's been some news recently about the processing times with IRCC, and they are through the roof, like insanely high, like 19
change?
years, like 50 years. And the immigration department has said that's not an error. So if that's the case, then people start to worry about, are we in a situation where we're going to have cancellation of entire swaths of programs again, like we did back in, I think it was like 2012, right?
Mhm.
So people start to get really worried when you have backlogs that are that long because there's no reasonable way to process them. And that means that it's possible that people can be heading into applications that there's no hope of actually having a decision on.
Yeah. And this is just all, it comes all part and parcel with the government's overriding desire to have people leave the country. And so it would not surprise me at all if they reverted back. This was something that the Conservatives did, like Alicia said, back in 2012. We had a backlog of over, I don't know, 600,000, 700,000 federal skilled worker applications. So before Express Entry was created. And with the pass mark at 67, it had been at 72. but the pass mark at 67 had made it easier for people to qualify, and there was no mechanism to not process. So they still had their quotas for how many they wanted. And in many instances, it was even quotas by office, although I don't know if they actually advertised that. But those quotas, in some regions, processing times were 6 or 7 years is what it would be for a federal skilled worker applicant to be processed. And the government said, well, this is not tenable. We can't, we can't continue with this. And so when the Conservatives got elected, one of the things that they pushed forward was this culling of applications. And so we know that there's a new bill working its way through the government, and we have to wait and see exactly what's going to come out with this. But there's been a lot of rumblings that the reason they're doing all of this is setting the stage to then say, look, processing times are so far out that it's not even practical. These people really, they'll never actually have their application processed. And so it's better for everybody for us to just cull them out and just return all these applications. And so it's a real concern for people. And this is something that we're having lots of discussions, because at the end of the day, people's ability to stay in Canada is really tied to their temporary resident status. And we have a lot of discussions with our clients on these topics, on strategies, on just looking at the options that might be available for you to be able to stay. And everybody has heard for years now, French, French, French. And the reality is, never before has it been more important to consider that as an option, at least until the government makes further changes, if they do. We know with the Francophone Mobilité, that program for work permits, right now it's still NCLC level 5. It's still open to all tiers, subject to some restrictions in ag, I think it is. But for the most part, it's not restricted. I just looked last night about those to see if there'd been any changes with the program, and there hasn't. It's still open for all occupations. And so it'll be very interesting to see if they then tighten things down with that. So these are all realities that people are facing, and it's part of the reason that we are so busy right now is just working to try to strategize with people. And in some cases, you guys, it is the decision, at least that we come up with, is that it's best for you to go home and to get more foreign work experience or things along those lines, versus staying here in basically a dead end position. And this also goes back to our Canadian immigration podcast. And so if you go back to, episode, well, at least in the fall, I think we started doing these September maybe of 2024. I guess it's a year ago now. We started talking about all of the various factors people needed to consider when they're making these tough decisions. And the series Time's Up was specifically designed to target those. So we encourage you to go back and take a look at those as well.
Yeah. So on this note, let's move probably on to the question. So the first question and the first comment that we got was from Francophone, and that's a super sticker. I've never seen those before. So it's a character line on the side, raising his arms while saying, "How's it going?"
Those of you on YouTube can see the little sticker that Francophone Abiji put there. So thanks so much. Give you a shout out there.
Cool. And then we will give a couple of shout outs. So Tulipa says, "Blessing on your all." Let's see. Hello, watching from Philippines. Great to see you all. And then we don't have many questions, so I encourage everyone, all of those people watching live, leave your questions in the live chat box, whatever you call it, because we want to interact with you. We're not here just to talk about our feelings and our visions of where the immigration's headed. We're actually to answer your questions, as long as those questions are not super specific and don't require us to give you legal advice. Because all we do here is provide you with legal information. Harpreet Dillon has a question for you, Mark. What is your earliest available appointment? Harpreet was trying to reach you for 20 days now.
Yes. Well, this is the first time in probably over 20 years where I've actually took a vacation where I wasn't connected to the office. And so I've had vacations where I've actually had consultations. And, I remember so many times work permits that, that I was doing late at night at some hotel in some country. I remember we made a trip to Guatemala and I was constantly stressed about having Wi-Fi. That was back in 2008 to be able to get some work permits out that I needed to finish for clients that were traveling. And so I was so grateful to have you and Alicia this last little bit. But for sure, the calendar didn't have a lot of availability. And even going forward, I'm coming back to 4 presentations that I'm doing. So one at noon today for the Alberta South CBA on express entry. Then tomorrow I have another one with the BC CLE on International Mobility Program work permits. Then Igor and I travel to the CELA conference in Toronto Monday, and I do a presentation on express entry there. And then I have one last one, at least in the modern, I should say in the most recent week here for LPEN, where we're going to talk about the Alberta Advantage Immigration Program. So on top of all the client work, I had not anticipated having all of these all at once. And in my zeal to just agree to do it, because I love to present, I kind of underestimated everything that I'd committed to. So that happens at times. So we'll definitely, Harpreet, we'll make sure that we get you in. Absolutely.
Mark, if you want to disconnect from office work, from my personal experience, I can recommend you can travel to Cuba.
Yeah,
and
that's a
it
good
works
spot.
just perfectly
No
fine.
Wi-Fi.
Like, you will not find internet there. So perfect way to disconnect.
The mountains are also a good place, Igor, that I found. Yeah.
All right. So let's see. We have a super chat from Salami Grace, but I don't see your question, Salami. Maybe you will be typing your questions a little bit later. Okay. Let's see. We have a couple of people asking about trade draw. So any hope of having a trade draw category? And then I think there was one more question. What exactly is going on with trades draws? Healthcare, education, and French are bowling, but not trades.
Yeah. Well, we can see we did have a category-based draw for trades. It was only one for September. I think people are looking at the kind of the allocation for trades and are expecting there to be maybe another draw of 1,500 or something like that. Traditionally, they've done that each year, maybe about 3,000. I'm not sure entirely if that's on their mandate, but we do know that we just had one in September, and I guess it's possible for them to do another one here in the fall. But this is the greatest mystery. Our crystal ball is a little foggy these days.
Yeah. And Mark, maybe on this note, I can also pull up a couple of slides that we prepared for this presentation, and maybe just give a little glimpse into.
Sure. Yeah. What I'm going to do here at noon.
Mm-hmm. Yeah. So let's see. How do I show it? Probably. Yeah. So I'm not sure if I can collapse the preview of the slides, but whatever. So you can see the number of invitations based on by the category and program, right? So CEC 19,000, education 3,500, trades only 1,200, STEM 0, agriculture 0, healthcare 10,000, and then French draws 29,500. Isn't that crazy?
Yeah. And the reality is, if we go back to those other ones, Igor, like you go back and you look at CEC, I have to assume that a substantial number of those CECs still have some element of French to them. And even the education and possibly even trades. So it's a heavy infusion or influence into the candidate pool is French language ability.
Yeah. I'm just wondering, was it even justified to create a category, go through all of those troubles trying to figure out what practitioners, what stakeholders think, just to invite 500 people in a year under a trades category? Like, they have rounds of consultations. They need to push the category. They need to vote on it. They need to determine the eligible knocks. It's so much work just to invite 500 people.
Mm-hmm.
Do you think something will change by the end of the year? Do you think they will invite more?
Yeah.
I don't think trades is going away, right? I think they want to have that lever to be able to pull if and when they need to. And so I think trades will stay there. But like we saw, they only did one draw, and therefore the CRS is 505, right? It's really hard to get a 505 CRS because technically, I guess most people are getting it under CEC, and then they just have that trades specific 6 months within the last 3 years. But and this is where Mark and I were talking before about
Mm-hmm.
clients who were like data scientists or in tech who literally went back and became welders or carpenters
Yeah.
and decided that in order to stay in Canada, they had to basically take another job, and legitimately, like, they had to go through and train and take another job in a totally different field in order to be able to qualify. So my sense on trades is they will keep it because we still do have a deficit in terms of Canadian trades workers. But it's always up to them when they decide to do that draw, and that matters a lot.
Yeah.
Well, lots of unknown. Um,
Mhm.
let's see. So the next question is from Arav Chaudhary. Sorry if I mispronounced your name. Pursuing bachelor's degree through a distance learning. Can I get points for it in express entry?
No. It's simple as that. No.
Well, it depends. So if you're trying to get points for Canadian education, no.
Yeah, good
And the
call. Yeah.
reason is Igor and I, on our last live, Igor developed this little well, it depends visual. So yes, Igor, touche, good point. But if you go to the ministerial instructions, and so I don't know, Igor, if you've got time to pull them up, but if you go to the ministerial instructions respecting express entry and the ones that are currently valid and in force right now, you can scroll down to section 30. And that is going to basically mirror what you see when you look at your express entry profile, and it asks you, do you have Canadian education? If you say yes, it's going to drill down and ask you a bunch of other questions. And so in order to properly claim Canadian education points, then you have to have had a valid study permit. You have to be authorized to work, or sorry, to study at the school. It has to be a credential. And so if you take a look at section 30, it says, well, it's a Canadian education credential if, and it has requirements on the bottom. And so it has to be, yeah, so if you go to section 30 and then you look at sub 3, and people have to have studied at a Canadian education institution located in Canada, so it's got to be physically in Canada. And then sub B says you've got to complete at least 8 months of that study on a full-time basis, and you have to be physically present in Canada for at least 8 months of that study or training, right? So this is where it has to be something that leads to a degree, a diploma. You've got to be at a DLI. It has to be under a valid study permit. It can't be an FSL training. And this is where it says under exceptions, sub 5, credentials obtained in a study or training program in which distance learning amounted to more than half of the program, are not eligible credentials, right? So you cannot do distance education and rely on it for Canadian education points. If you are asking, however, maybe you are doing a foreign degree and you're doing that online, maybe it will qualify as a foreign degree, but you have to go through an education credential assessment through one of the testing agencies that does your equivalency analysis to see whether that foreign distance education would be considered equivalent to a Canadian bachelor's degree.
Right. All right. So we still don't have a question from Salami Grace, but we have Harpreet clarifying what the question is all about.
Okay.
So I have withholding of removal granted by a judge and have a work authorization. My wife is a Canadian citizen and currently living with me on E2 visa. We wanted to apply for spousal sponsorship application.
Okay. Must be in the US.
Mm.
Yeah. Yeah. Well, that's definitely a consult, my friend. Good call.
Yeah. Okay. Next question. I'd like to know, how long does it usually take for a spousal application to be approved after submission? Oh, okay. While you guys
So,
answering, I'm just gonna pull up the processing times.
yeah. So it really depends. Did you file an inside Canada application under the spouse or common law partner category? Did you file an inside Canada application, but you did it under the family class? Or did you file an outside Canada application under the family class? So take a look. I wrote a blog article maybe about a month ago now on spousal sponsorships and why it matters when you're looking at FC1 versus spouse or common law partner class. The processing times are quite different. So Igor is pulling up the processing times, but
I
historically,
can't. I can't because they changed the layout. So now you need to select the actual month and year when you applied, and it tells you how many people in front of you and how many people are still waiting.
Mm-hmm.
So
all right,
let's assume April.
let's make something up, Igor. Yeah.
Yeah.
So spouse or common law partner living in Canada outside of Quebec. So estimated time left, they're saying 12 months left if you submitted in April of 2025.
Yeah. Yeah.
Okay.
And it says like if you apply now, it takes 22 months.
Mhm. So what we've been seeing before they changed the format on the processing times webpage was it was about 2 years for a family class, sorry, a spouse or common law partner class in Canada, and it was about a year-ish for the family class.
Mm-hmm. Yeah. Okay. All right. Next question. I applied for a closed work permit from outside Canada with a positive LMA. Do you think the new changes will affect my chances?
Mm-hmm. Oh, okay. Well, one thing we know is that everything is becoming more difficult. If you look at the study permit applications, the drop in approvals, let alone their targets for study international students in Canada, we've seen a real drop in those. On the work permit side, they're also trying to restrict and reduce. So we know that they are heavily focused on reducing the number of temporary residents in Canada as much as they have attempted to reduce the number of PRs, individuals that are transitioning to permanent residence or immigrating to Canada. So in every case, the world is much different now than it was even 2 or 3 years ago. So when it comes to applying for a closed work permit outside Canada with an LMIA, the new changes, ultimately, if you meet those requirements and you're answering the questions properly, you're demonstrating that you have the work history, the education, exactly what was requested in the LMIA, an officer doesn't have, what's that?
The language.
Yeah, language. An officer, like, they don't have the ability to just refuse because they don't like you, but they can sure put the onus on you to satisfy them that you meet all of the requirements. And so gone are the days when you can just toss something in with very little effort and forethought and just expect that it's going to get approved, because they are looking to refuse.
Okay. This one's good. My children and I got our immigrant visas and confirmation of permanent residence on April 10th, valid until February 2nd. But my husband, the principal applicant, has no update. If our visas expire, can IRCC reissue those?
Wow, what a mess.
This one's tough. I mean, normally, if you have valid landing visas, you ought to be able to land. But I have heard stories in certain instances from people who were the dependent applicants and the principal applicant hadn't landed yet. And IRCC said, no, the principal applicant has to land first. So this one's tough.
Yeah, that's clearly a mistake. Like, they should not be issuing dependent visas and COPRs before the principal applicant has had theirs issued. They are dependent on the principal applicant. So I'm not sure what the history is. Clearly, there's a lengthy one here. I'm sure you've had previous immigration representatives working with you. Ultimately, if you want to book a consult, we can try to dig into this for you and try to understand what's happened. But this is absolutely very, very unusual to have these types of situations. it's an error on the part of IRCC.
We have lots of very specific questions. For example, this viewer says, hello, I'd like to get some clarification and reassurance on a few points regarding my express entry application. I'm not sure about reassurances, but we'll try to answer your question. So in my express entry PR application, I mentioned openly that I had previously claimed refugee status in South Africa. I have never been illegal in the country. Could this in any way affect my PR application? Well, first, good that you disclosed it, right? That was the first step, right?
Yeah. So people often ask questions about potential inadmissibility, and the answer is that you always have a positive obligation, just like Igor said, to disclose. You have to, because immigration is going to do their own digging and they're going to do their own security and background checks. And if they realize that you did not declare something, then that's a ground for misrepresentation and that's a bar for 5 years. So you have to disclose. In terms of whether that can affect you, it really depends on what happened with that previous case. Were there criminality allegations against you? Were there charges? Is there something that could make you inadmissible to Canada or not? And so the mere fact of making a refugee claim is not in and of itself an inadmissibility. You do have to declare it, or it could be misrepresentation. But often when people have a previous refugee claim, there might be something else. So there might have been a charge against them, or there might have been, if they failed to appear, if there's an immigration warrant, if there's something else that could amount to a criminal charge in Canada, IRCC is going to want to know about that as well. And it might affect family members depending on if you are applying on your own or if you have accompanying family members, and what the substance of that claim was in terms of spouse and kids and all that sort of thing.
And I think we have a follow-up question. I also declared my previous visa refusals, 2 in the UK, 1 in France, and 2 in the US. Included a lot of explanations stating that those refusals were purely due to financial constraint at that time. Will that affect?
Yeah. And usually when you have these types of situations, the most important thing is just to disclose. Now, why you had a temporary resident application refused to whatever country, usually the details are not as big of a deal unless there's, something a little more serious involved with it. Like there's criminality or something like that, that would also cause you to be inadmissible to Canada. But when you have these prior visa refusals, sometimes people feel like, well, if I got my visa refused to Canada, refused to the US, it could affect my ability to get express entry or a permanent resident visa to Canada. And that's simply, like I said, subject to some very rare exceptions. That's not the case. If you're refused for, they just don't believe you'll go home, right? Which is often the case in some countries. Those types of refusals are not going to negatively affect an express entry application. So disclose, absolutely disclose.
Yeah. All right. Let's see. We will give a couple of shout outs as well to people who pile in. Hilamani says, good morning. We have Joe, as usual.
So Hilamani, go back to Hilamani there. So Hilamani, he's probably not watching anymore. He's a good friend. He lives in McGrath, just south of mine. He's a phenomenal pickleball player, really good. Also a really, really good rugby player, obviously by his name. So he's a good friend. So good shout out to Hilamani. Yeah.
We have a shout out from Joe. He calls us Trio Fantastico. I think we can add it to our motto on our website on the homepage. Let's see. We also have Spider-Man. Hello from Ho Chi Minh in Vietnam.
Oh, wow.
Hello.
Spider-Man is all over the place.
Yeah. All right. Let's see. Oh, we got one more super chat from Fantahoon. I think we've answered. Oh, no. Fantahoon just sent us a super sticker at the very beginning. And now there's just a super chat. Well, thank you so much. If you have any question, let us know. Okay. All right, let's move on. So,
and just post the question, Fatahoon.
Yeah,
just post it, and we'll know it's a super.
Yeah. So Joy Vikata is asking, please confirm if a principal applicant on an inland spousal sponsorship application, while that application is being processed, leaves Canada for a few days, is that okay? Does the principal applicant need an ETA to return? Yeah, lots of questions.
So we got to go back to first principles on this one, right? You're a citizen of which country? And I'm assuming that you're a Canadian permanent resident, right? And so if you're a Canadian permanent resident, then you need to have some sort of valid passport from another country, plus your Canadian PR card that ought to be valid. The ability to enter Canada is going to depend on having that ability to prove that you're a PR. So you've met your residency obligation and you're coming back in and you have a valid passport. So I'm not sure why they would need an ETA in
I
this.
think, Alicia, I think and this is always the difficulty, you guys, with these questions. I think this person is the subject of a spousal sponsorship, an inland. So they're the principal applicant on an inland spousal sponsorship. And they're saying, can I leave? Because obviously the government says, if you leave, you could get your application rejected. And I think that's what's driving the ship here. So I'll
I
just
was taking
clarify.
it from the sponsor's perspective,
Yeah,
but
yeah,
I think,
exactly.
yes.
Yeah.
Yeah. So if you are the person being sponsored, and this is entirely dependent again on what's your nationality, what's your visitor visa status, are you a national of a country that requires an ETA or a visitor visa? And what kind of application did you file? And so this is, if you did an inland spousal sponsorship application, this is always a risk. If you leave Canada, it's technically possible that once you are no longer in the country, an officer could say, well, you don't meet the requirements of a spouse inside Canada with valid visitor status or study permit status or a work permit status anymore. And it's theoretically possible that they could cancel your spousal sponsorship application. So that is always a potential risk if you have filed a spouse inside Canada spousal sponsorship category and you leave.
Yeah. Wow, we have very good questions today, lots of them. I'm just trying to figure out how to pull all of them and fit it all in 1 hour. Let's see. Okay. Okay. This one from Salami Grace. This was the super chat. Okay. I have both home support and personal support worker experience in the same healthcare staffing agency, and previously applied for home support worker program in March. Will this be a misrep?
You can ring that bell. Yeah. This is.
Yeah, so we would need to get a whole bunch more information from you and understand your situation in much more detail. So in these live streams, we try to answer general immigration questions. We cannot provide individualized immigration legal advice. We can do that if you book a consultation, because we have obligations as lawyers, we have obligations to the Law Society to make sure that we are getting proper ID for our clients and that we are getting enough information to understand their situation before we give them legal advice. So Salami Grace, we would really need to understand, how long ago did you file that application? What were the periods of work? What not category did you choose? What sort of supporting evidence did you have from your employer? How many hours did you claim? And then I'm assuming that you have some other sort of express entry application where you're saying that, for that same period of time or maybe an overlapping period of time, you have a different knock for that category. That is always potentially risky, because if you are saying something that does not agree with what the application is that you already submitted to IRCC in the past, there is a potential risk that IRCC could say, hey, that's misrepresentation. You can't claim one job under two different knocks. You have to choose which it was and have supporting evidence for it. But depending on your circumstance, maybe there's a way you can say, I had one job, I transitioned to a different job after a certain date. You've got to look at hours. You have to make sure that you are, in fact, meeting eligibility requirements and that you are and your employer are on the same page and that they agree with the fact of your assessment in terms of if you are changing knocks.
Okay. Let's see. Okay. This question. I got my nomination through Alberta Opportunity Stream and applied for permanent residence at the federal stage now. Now I want to change my job to another one with a different knock. Will that affect my PR application?
You guys, these are nasty questions. So just like Igor, you can flash up your little thing there, your little, well, it depends, because it really does. The Alberta Opportunity Stream is not traditionally, at least it wasn't designed to be employer specific. But over the years, because of, well, have to assume fraud or program integrity or whatever it might be, the government is really, really putting a lot of emphasis on an employer supporting even that application, at least for various points. So it may be possible, if you structure things correctly, to have a change in your employment, but there's a lot of pieces that need to fall into place, including possibly getting concurrence from the Alberta Advantage Immigration Program that they're okay to change positions. Your new employer submitting all of the employer attestation forms confirming that they're supporting your work. So it may be possible to do it, but it is not just a simple matter of, I'm just going to work for another employer and it's all good. I don't need to say anything about it. That is not the case. So that's why we constantly are saying book a consult, because there's a lot of moving parts here, and there's not just you involved with this, but it's the employer and the Alberta Advantage immigration program that has to be on side, even in the context of an AOS application.
I just recently had a consult with someone. Essentially, the application was already submitted to the, not to the federal, like to the IRCC, but actually to the provincial government. And then they decided to come back to the applicant with an ADR and essentially a PFL, saying, we suspect that you worked in different NOC throughout the period of your employment, after you submitted an application and before we actually got to review it. And what happened is the person covered up for someone who was on a maternity leave, and the employer said, "Oh, it's just fine. You know, you can just you can continue working." And I'm wondering, like, where is that employer now? You know, when the problems arise, like, good luck trying to find someone to blame. And the only one to blame is the actual employee who did not seek legal advice before making such an important decision.
Yeah,
So
so
very important.
take a look at the AAIP and the program eligibility requirements for AOS. And if you go down, it says eligible job offers, right? All applicants, including PGWP holders, must have a full-time job offer or employment contract from an Alberta employer to work in their current occupation in Alberta. And this is important. The when is important. When the application is submitted and when we assess it, right? So it seems like you've got your nomination. I don't know if you've submitted your PR application through the PR portal or not, but if there's a material change in circumstances, then later on the AAIP website, it says you have to notify us, right? So if it's something where you have to notify AAIP and it could change whether they would give you that nomination, Mark's absolutely right. Now you've got to make sure that the new employer has been vetted, they're an eligible employer who meets the employer requirements, they've submitted their employer declaration form and business legitimacy documents, and AAIP has to sign off on that, because if they don't, then it could result in AAIP canceling your nomination, and then everything on your PR portal is going to fall apart with IRCC because you no longer have the nomination.
Yep. All right, let's move on to the next one. And this one is interesting. So, based on the recent public policy to clean all express-entry inventories in 2025, I wish I could see that public policy somewhere.
Yeah, I'd love to see that too.
Do you think people whose applications are under security screening are covered by this public policy?
Yeah. Maybe go to that chart in our presentation, Igor. The one that shows the projected processing and how many are over the projected processing. So like we talked about at the beginning, if you're late to join at noon, I'm going to give a presentation on express entry tips and strategies and tactics and things like that for express entry. And you'll see here, this is right from the government website. This demonstrates the backlog for federal high skill, which is essentially express entry. So in your comment, you suggest that they are going to clean out all the express entry inventory in 2025. Well, if you're referring to EAPR inventory, really they don't have any inventory other than what they are able to process. That's the very nature of express entry. Back during the pandemic, there were a lot of issues with people being able to travel, officers not being able to process at all. And so the vast majority of applications were literally stalled out. And then we had most of them, I think 23, 24 months was almost some of the highest processing times that they'd projected for express entry. But 6 months is what's supposed to happen. And if you look at this chart, you'll see that that line is basically about 6 months. And so you'll see the vast majority of applications are truly processed within that time period. There's a little bit of a blip you can see recently, but in the last little stretch here, they're right in line with that. So I'm not sure, and when it comes to express entry profiles where there is tons, thousands and thousands of people in that queue, well, those time out after a year anyways, and are they expire and you have to resubmit them. So not quite sure, like in terms of express entry inventories, if that is indeed the case. Now, with the other lines of business, if you will, for immigration, such as H&Cs and things like that, where processing times are astronomically higher than what we would have normally expected. We know that there's a lot of buzz right now about the fact they could just call them out, and it's a real concern. But ultimately, when you've got 30 years processing on an application, that's clearly not that's not a manageable figure for anyone, the applicant nor the government. So something has to give.
All right. Can you please confirm for express entry is CELPIP's 2-year validity counted from the test date or reevaluation result date?
Reevaluation, I think, would be the date that I would go from. Because you'll have a new result date. Reevaluation, though, I'm a little bit confused. So I'm assuming that went back and retook it. What exactly do you guys know about reevaluation? This is
I would
I'm not
always say the test
sure.
date, because to be conservative, I would always go with the test date, because even if you have like another result date there's always a delay between the date you write the test and the day you actually get the results. I would always be conservative and go with a test date.
Yeah, it's probably the wiser choice. Obviously, if you are March 2025, you still have till March 2027. So if there isn't a specific reason, I had a situation where someone received an ITA and the question was it the test date or the result date? So was the day that I took the test or was it the day that I had actually received the results? And yeah, the results must be less than 2 years old. So thanks, Igor. And so we were, at the time, it was early on within express entry, and they were running out of time because they were not going to be able to get their application submitted, their EAPR, before the expiry of the date they took the test. And so it meant something. It was meaningful. The consequences were pretty serious. And so after doing some digging, it's the test date. So but it's better to always err on the side of caution.
Do you guys remember that question about distance learning? And we said it really depends whether that's in Canada or outside Canada. Well, we have a clarification saying that it was a bachelor's degree from one of the universities in India. And the question is it eligible for WES? Well, you probably need to ask WES if they will accept and assess your education and find an equivalency. That's probably is the best way around it.
Yeah.
Okay.
So
go ahead, Alicia. Yeah.
So keep in mind that when you're looking at foreign education, immigration will only accept education credential assessments, so ECAs. There are a number of different organizations that will do an education credential assessment. WES is one of them. But depending on the type of degree you did and the schools that you did it at, some of those testing organizations don't think that they're equivalent to a Canadian bachelor's. You can, however, ask for multiple opinions. You can go to
Mhm.
IQAS, or you can go
And
to
forum
any of
shop.
the other, yeah, you can ask other organizations, do you think this degree is equivalent to a Canadian bachelor's, yes or no? So if WES says, I don't think it is, you might be able to go to a different education credential assessment. They has to be one of the ones on the list with IRCC, but it might be possible to get different opinions, and you can use whichever of those ECA assessments is most favorable to you.
Yeah. And back in on July 20th, but I don't remember exactly the year. I did a blog post comparing different ECAs and how they assess different um, degrees and what documents they ask for. So go in and find that blog post on our website. So it's how to choose an ECA organization. That might be a good starting point. All right. Next question. Why do you think the non-express entry timelines are quite high? Recently, the minister said they're going to increase allocations for PNP to provinces. Do you think it will bring the timelines down? And this is actually very interesting, Mark. So as I was helping with the slides, I compared the 2024 immigration level plan and 2025 and the number of PNP allocations, essentially PNP applicants that they will admit, and it just like it tumbled like it like twice as low compared to what they actually
110
projected
down
for
to
2024.
55,000. Mm-hmm.
So, like, what do we expect for next year?
Mm-hmm. Well,
Well,
we know that within 2 weeks here, well, before November the 1st, right, the government is required to release its annual levels plans. So we will know at least what their plan is for 2026. It's always interesting because these are 3-year plans, but they're not locked in stone. So they're kind of guidelines, guiding principles on what they expect they will do, but they can always change it the following year. So in the early days, they would do them each year. Now they kind of give an outlook for the next 3 years, what they're thinking about, but clearly based on what happened this past, well, a year ago in 2024, they drastically altered their then 3-year plan that was issued in at the beginning of 2024, or I should say 2023. I think it was October then. So anything can happen. I personally am not holding a whole lot out for the PNPs. There might be a little bit of an increase, and we have seen even Alberta getting a few more, right? So recently, um, it went up from, what was it, 4,700 to, I think are we a little over 5 or 6? I can't remember. I think they added another couple thousand on there, didn't they? I was just looking at this just before I went on vacation, but I can't remember the actual figure. So let's see if I got it here. Yeah, there's 6,403 now is the nomination allocation. So they did add some more on. So it wouldn't surprise me if they maybe threw a little bit more of a bone to the provinces and maybe bumped it a little bit. Will it return back to 9,750 for Alberta, or the over 10,000 for Ontario? Like that's something I can't see happening. I've always said that I'd love to see 75% of the economic allocation be given to the provinces, the overall threshold, whatever the levels plans are. I would love to see 75% given to the provinces. Let them, choose the bulk of the economic immigrants, and let the federal government oversee all the other areas, which are fulsome. But right now, I think our federal government really wants to try to continue forward with their plan. And the best way to do that is to control things. And so that's kind of the direction they seem to be going.
Mm-hmm. Okay.
What's your thoughts, Alicia? What's your thoughts? Or Igor? Yeah.
yeah, I'm reading a really interesting book on rhetoric right now. And one of the things that it's
You
talking
better
about is
define what rhetoric is for our viewers, Alicia. They
okay.
probably won't be familiar with that word.
Okay, so rhetoric is sometimes viewed as the way that you use words to make an argument or persuade somebody, right? So what sort of language do we use, and what are the underlying assumptions when we make different language choices? And people might think that's not important, and it's hugely important, and it affects us really fundamentally in ways that we often are not aware of, right? It shapes our thoughts and it shapes our discussions. And one of the underlying divisions, going all the way back, and she goes all the way back to like Socrates and Aristotle in terms of how you make arguments and why it's important, is this division between the individual and the collective, right?
Yeah.
So
State.
to what extent do you think that individuals ought to be making decisions, or smaller groups, versus is it the good of the collective, right? Is this a larger societal structure? Is this a structural argument, versus is it an individual argument? And so I think really this kind of tension between how much do the provinces get versus how much does the federal government get in terms of decision making is a similar argument, right? How much do we fundamentally believe that individuals should have the ability to make decisions and come up with self-determination, or make a choice that's going to affect them, versus how much do we think, well, we need to look at the collective good or overall goals, or make structural decisions based on what's good for an institution or for a whole group overall. So I think it's an interesting tension between provinces and federal government, and I think it's that same tension between the individual and the group.
So, Alicia, are the numbers going to go up, or what's going to happen with the PNPs?
I agree with your assessment, Mark, that I don't think it'll go up a huge amount. I don't think it'll go back to the levels that it was with 110,000. I think that, yeah, they may increase it marginally from the 4,000 or the 5,000 that provinces had. Maybe they'll increase it to a 6 or a 7, but I agree that I don't think it's going to go back to where it was.
And I'll be honest, you guys, I was quite surprised to see the jump with Alberta. To go from the 4,750 to the 6,403. I'm actually quite surprised to see that happen at this time during the year, because that literally, I think, happened. When was I don't know if they have the last October 8th. October 8th was the last update, right? And so those additional spots that were then added in, where did they come from? So I have to assume Alberta wasn't the only province that was given a few back. And so we know that in the past, some provinces just didn't use all their spots. So then they would reallocate or shift things around. And we also know within the annual levels plans that 55,000 is the median, right? Like it's kind of their target. So they do have room built in to go a little higher. I can't remember exactly. Let's see what was, actually, maybe I even have it here. For PNPs, they have, let's see, family 55. Yeah, up to 65,000 is for 2025 is what they did kind of build in on the higher end. So maybe they're just choosing now to allocate a few more, which I'm not complaining about, that's for sure.
And to answer the question with the processing times, the reason that you have much longer processing times with the non-express entry is because now you've got two different streams, right? It's not just through express entry. You now have the whole provincial nomination process. And then after you've got that nomination, you've got to submit that through the PR portal. And that PR portal is nowhere near as streamlined as the express entry portal, right? And so it's a whole different process, and it's got longer processing times. And my sense on that is if there's more allocations, if there is, it's not going to bring the processing times down if you have more applicants going through PR portal non-express entry linked applications.
Yeah. I'll just, Igor, if you can just hit the second to last one, mourning why IRCC doesn't recruit more employees. Can you pull that one up? It's the very last, one of the third last comment now, I think, on our list there.
I'm not sure if I can see it here.
Let's see. Okay, well, basically, one of the comments, you see it there? Yeah. One of the comments says, why does IRCC not recruit more employees? This would improve the speed of consideration of all applications and shorten the deadlines. Absolutely, it would. Okay, so like Alicia talked about, there's a couple different factors at play. And usually when it comes to processing times, one factor is they're only going to process so many in a given year. So those levels plans. And Another factor is that they have budgets that they have to adhere to. And when the budgets are not running so well, they have to make cuts. And those cutbacks across all departments that happen and are happening throughout, this year in particular, are affecting all different departments within within the government, including immigration. So they went through and they actually laid off and terminated positions of a lot of immigration officers, temporary. I don't know all the details behind it, but those on more temporary contracts. And that's kind of contributing right now to the issue. So they don't have an endless supply of money just to hire more people. I remember having a conversation with, I think it was Minister Fraser, when it was the year after I finished as the national chair. Was the past chair was still on the national executive, and we met with then Minister Sean Fraser, and we talked about this exact thing. Hey, processing times are starting to climb. Why don't you hire more officers? And he said, hey, I'm constantly looking. This is before money became an issue for our government, or at least a concern. He said, hey, I'd be happy to hire anyone, but I'm literally trying to find people just like everyone else. But if they can walk and they can breathe, we can teach them, right? But we're struggling to hire. And so that was the position back, and I think it was 2022, I think it was. And now since that time, even though there's still a need, even back then, nothing has changed. The volumes are still high. Government said we just have to reduce. We've got to reduce our expenses and try to bring our budget within line. And so it's not definitely, that would be a real quick solution for sure, but it's not in the cards.
Let's have some fun. What if okay, I just came up with another conspiracy theory, and
nice.
This can make helps.
Yeah.
What if they invite more Francophones to attract more potential new IRCC workers who are bilingual? What if it's part of the plan?
Oh, that's funny. Hey, well, you know what? You have a greater shot of getting a federal government job if you're bilingual, because we're a bilingual country. So, hey, maybe they're trying to recruit more people to hire later. Maybe.
Yeah, but you know what's more fun? This question. Okay, Mark. That's
it's those, what do they call those things on your phone? Those filters. Oh, yeah. Igor has a filter on his computer. Yeah. It's lose 5 years. It's because Igor is going to be a new dad. And new dads have this new vim and vigor in life as they prepare to welcome their first child. That's why.
And that's the magic of my new haircut. And me actually taking the time to shave.
That's it. He shaved. He doesn't look as scruffy today. That's why. Great
All right.
question.
So let's see. Tulipa's asking, what likely to happen if I don't have enough funds in my account for my dependent to come to Canada as a PR?
Tulipa, it's hard. We don't know which kind of application you filed.
We don't know where you're at. You haven't even filed it, right? So, yeah.
Yeah. So we're not sure if you're eligible to sponsor, right? Are you already a Canadian citizen or permanent resident and you're bringing a dependent sponsorship of kids or maybe a spouse? We don't know if you are just applying for maybe express entry or a different economic application. So there are requirements that depend on the program. So if you're looking at express entry and you don't have Canadian experience and you're not getting drawn under a CEC category, you have to prove those settlement funds. And if you don't have the settlement funds, you're not going to get approved and your dependents won't be able to come and your application will get rejected. If you're looking at a sponsorship of a spouse or dependent children, then you have to already be a Canadian permanent resident or citizen. You have to meet eligibility requirements and you have to sign an undertaking of support. So you basically have to say, if your family members come to Canada and go on social services, the government can come back at you and recoup that money from you. And so you have to show that you've got enough money to be able to actually support yourself plus your dependents. Otherwise, they could say you could be financially inadmissible. So there's a financial inadmissibility test under a spousal sponsorship, even though technically you don't have to meet those low income cutoff guidelines. But you do have to show you're not going on social services or getting benefits for reasons other than a disability yourself. So it depends.
Yep. All right, so we have one interesting question. So we've got permanent residence through PNP Express Entry and the claim points for living outside Calgary. We're in Lethbridge. Will it be a problem if we move to Calgary 6 months after getting permanent residence?
Yeah. So this kind of harkens back to the letter of the law versus the spirit of the law. So within the law, there's no restrictions on moving within a province, or technically even moving within provinces like across the country after you become a permanent resident. But the key thing that you have to understand is at the time in which you become and you're going through that landing process, that your intention needs to be exactly what you put in your application. And it becomes a little gray when people say, well, okay, I got those extra points for living in rural Alberta. And, but I know, like, I'm just here long enough to get my PR and then I'm heading back to Calgary where the real jobs are, right? Even though, why would you ever leave Lethbridge? Seriously, it's the best place in the world. And so it's a fine line. In our office, we don't really delve into those things. We don't delve really in probabilities. We only look at possibilities. And what that means is every bit as much the letter and the spirit of the law, we really counsel our clients to follow it. Now, when you're going through in this particular situation, it goes really fast. So it's not like you're going through the AOS where processing times are almost 2 years now. Express Entry goes pretty quick when you get your nomination from the province and then you apply through Express Entry. You know within 6 months you're going to get it. So we don't know where you're at in your process. And right now, if you know that you're submitting an application, you know you're not going to stay, you're going to be gone. I've got reservations with that because I think that's misrepresentation. But if you've already become a permanent resident, which you said here through the Express Entry, I don't know how long ago it was. And even then, a temporal factor isn't something really other than maybe an indication of intention. I just like people to give a good shot where, really do what they can to make things work in the place in which they, that really allowed for them to get permanent residence. That's why the system is all geared that way. That's the spirit of the law. But the letter of the law, if you've become a permanent resident, there's nothing stopping you from moving to Calgary. There just isn't.
Okay. Remember, we got a super sticker from Fantahun Abetri. I just realized that he sent 2 questions and I somehow missed them. So, Fantahun,
Sure.
sorry. We'll pull up your questions now. So, I have submitted my application. Under my child section, she's a Canadian citizen. There is a family member proof of status requirement. I submitted my child's passport and birth certificate, but now I believe that that may have been incorrect. I should have submitted my own and my spouse's proof of status in Canada instead. Could you please provide suggestions on how to correct this? It's a PNP through the Express Entry system.
Yeah. Like if you've already submitted your EAPR, then use the web form as quick as possible and try to save it. Right? Go to the IRCC web form and upload all the information that you feel you should have included but didn't. You want to do that as quickly as possible and try to correct it. There's no guarantee, right? This is the challenge with this stuff right now. IRCC is being cruel. They were always cruel since 2015 when Express Entry started. They have always been apt to use their discretion negatively versus positively. And so in your situation, that's what I'd recommend. You take whatever steps you can to correct it.
Yeah, it also depends, Fantahun, on what you submitted where, right? Like people bundle their documents differently. And so if you already somewhere submitted that you and your spouse, I'm not sure if it's you or your spouse who's the principal applicant, but whoever the principal applicant was, you submitted proof that, everybody has their passports, everybody has their marriage certificates, everybody has birth certificates if they have kids, and then you also have your uploaded your proof that you are eligible to work, whoever the principal applicant was who's claiming work experience in Canada, if you put that somewhere, it might be okay. It's really hard to tell depending on how you bundled your information and what you uploaded.
Right. Oh, Mark, this one would be interesting, and perhaps you
Okay.
can answer this one. So, study permit expired before I received my completion letter. I also applied for an extension of my study permit before the expiry to maintain my status. Can I now get a work authorization letter if I apply for postgrad work permit? So I understand the study permit extension application is still being
It's still
processed.
pending. Yeah.
So Video, my first question would be, why did your study permit expire prior to getting your completion letter? Because almost always IRCC issues the study permit for 90 days longer than your program of studies. And so
They
it's
changed
it's
schools.
rare.
Change
Yeah,
schools,
maybe.
100%. Yeah.
So, we'd always want to know, why did it expire? Did it take longer for you to complete your studies? Did you change schools? Did you go part-time for part of your program? Did you do a leave of absence? Did you get authorization from your school to get a leave of absence? Did you get an updated study permit? Because the new rules are that you can't just change institutions without getting that updated study permit. So we'd want to know a whole bunch more about what went on with that, just as a starting point.
Yeah. Yeah, as far as can I get a work authorization letter if I apply for a postgrad work permit, this is not something that we can tackle here, my friend, unless we have a consultation. Interestingly, this is one of the topics, Igor, in the CELA conference that they're trying to get a government speaker to come. And fortunately, I have an awesome government speaker that's going to be attending my express entry, a policy person, which is fantastic, that are going to be there to speak in Toronto with me. But these types of situations, maintain status has become one of the muckiest, muddiest areas in immigration. And I really don't agree with the direction IRCC is going. I understand the rationale. They're trying to punish people who just submit frivolous work permit extensions. And this is really where it's come from. What do they call them? Dummy extensions. I can't remember the common vernacular they use, in the social world. But ultimately, these types of permits, and so people will file an extension, and then they will try to submit another one once things sort themselves out, so they can buy themselves time till things work out. And to some extent, then study permit people who have applied to extend study permits and other documents are being caught by these maintain status rules. Because effectively, if you submit an extension application and that application is rejected, if you were to have submit a second application during that maintain status time, they will refuse it because they will say that your status ended on the date in which your original document expired. And it becomes really problematic for us trying to advise our clients in these situations.
Yeah, and the risk, Video, is that there are two different things that are going on. There is the ability to maintain your status, and then there is the ability to have implied status to work. And those are two different things. So we're looking at 186 and we're looking at 186 sub W versus 186 sub U. And so when you do not have a valid study permit before you are, like a valid study permit at the time that you're submitting your PGWP, then you no longer have the same ability to have maintained or implied status to work as soon as you submit your PGWP. And so IRCC is looking at that very narrowly. So if at the day that you submitted your PGWP application, you don't have a valid study permit,
Yeah.
then you don't have maintained ability to work.
Yeah. So, in summary, Alicia and I are more on the side of it ain't going to happen, my friend, getting that authorization to work the day you file your postgrad until your study permit is actually approved. One of the challenges that you have is timing. And with these lengthy processing times, you may not get a decision on your study permit before you have to file your postgrad. So that's why we recommend people book a consult so we can try to take a look at it and see if there's things that we can do. It's so hard. People have to be so on top of their applications. They have to understand the law. They have to do things proactively, quickly, not delay, well in advance. And this is what we do with all of our clients. But oh my goodness, we have a ton of consultations right now with people in similar situations to you, where in in some circumstances, there's not much that we can do. It's a foregone conclusion that the study permit isn't going to be approved. And, just through the basic PGWP rules, you're not going to be eligible to apply for it. So.
Oh, this one is interesting and very important. Can I use IELTS one skill retake results for PR in Manitoba under PNP? No, you can't. Simple as that.
No.
You can't for express entry.
Yeah, but like they would follow the same rules regardless.
Yeah. I don't I don't know for Manitoba for sure, but I have to assume that the provinces all follow the federal rules to a large extent, at least the negative ones. Some of the positives, like for example, when they allowed Pearson to, they accepted Pearson as one of the approved language testing organizations. It took a while for some provinces to get on board with that. So for the feds, that Pearson may have been fine, but for say Alberta, they weren't quite on board with it, and it was just IELTS and CELPIP. So.
Okay. Binhu is asking, now that IRCC doubled on the processing times for AIP applications, can applicants go to the federal court for justice? And I think there was a somewhat related question about going after the government, where Neil asks, many H-1B workers moved to Canada in good faith, but now have no citizenship path. Did the government fail us? Is there any legal way to fight back?
Yeah.
So, and maybe Igor, you'll want to speak to this because you're doing most of the JRs, but my 2 cents are that for the first question, if you've had an AIP application that's in process and now you see the general processing times are twice as long, when we're looking at a mandamus application, we're always looking at what was the last material step in your application. We're not looking at general processing times by and large. We're looking at what was the last material step in your application. And there is a little bit of what's a logic test based on how long other people are having their applications processed, and is it unreasonable? So it's really important that you keep in mind that just because processing times are now advertised to be something different, how long ago did you get that AIP application? And what was the last material step that IRCC made in processing your application? And then you can maybe look at comparing it to what's going on with other people who are in that category. And sometimes there is the possibility of doing like a class action suit, or you get together with other people to say, look, it is not reasonable in terms of the processing delays in this category of application. And sometimes the federal court has normally said that if you have processing times of less than 2 years difference from what it is, give or take, you're probably not going to win on a mandamus application, but it does depend on the individual circumstances and when last material steps were taken in your case.
And it's also important that when we prepare mandamus applications, we try first to demonstrate that there was an unreasonable refusal, that the applicant is not responsible for the unreasonable delay, that the applicant is not responsible for the delay, and that this unreasonable delay amounts pretty much to an implied refusal to process your application. And so when, for example, we have a client who's just been waiting for 3 years, and that just recently RCC was doing something on his file, there's no implied refusal to continue processing. You can see that they're working. Yes, it takes ton of time for them. Yes, there might be a delay in previous stages of their application, but the application is in process. It's going somewhere. Again, maybe it will take me some time to find the exact quote from the case law that I often cite in my application records. You have to demonstrate to the judge that even though the RCC is saying, "Oh, your file is moving towards finalization," the judge said, "Yes, I take their argument. It's moving somewhere, but it's moving nowhere, essentially, right?" And if you can demonstrate that, then perhaps yes, mandamus is something that you may proceed with. But for everyone else, and especially speaking about the second comment, we understand the frustrations. And we understand that people come with different expectations as well. But it really, like, each case turns on its own facts. And um, if you consider applying for a judicial review, or pursuing Mandamus application, please reach out to us and let's have a talk. When especially like with those assertions that the government failed the applicants who came as H-1B holders. You came as temporary residents, first of all. Nobody promised a pathway to PR or citizenship. You demonstrated proof of your temporary intent. You demonstrated that you will leave Canada. And so the expectation of the government is that you will comply with whatever you claimed in your application. They did not create this program to allow you to come and stay here permanently. Many people will, and the government will gladly accept them, but it's nowhere a guarantee that everyone must be allowed this opportunity. It's a privilege, right, as they say.
Yeah. And I'll jump in there too. So I was heavily involved in the H-1B open work permit process. And I worked with a number of individuals, created a specialized course for it to assist people. And at the time, then Minister Sean Fraser, I remember he appeared at the Collision Conference heralding this, that he wanted to make Canada the big tech hub. And he highlighted other programs like the Digital Nomad Visa, which for all intents and purposes wasn't an actual program. It was just, anybody can come and stay for up to 6 months and on the initial entry, showing that you're not actually taking up a job in Canada, you're working remotely for your employer who lives in another country, and you're just here experiencing, the beauty of Canada, right? So that's the whole concept of a digital nomad. And then the H-1B, those 10,000 spots were designed to encourage people who were kind of stuck in H-1B visas in the US with no future. Because remember, you guys, right now, everything that we're seeing here has been in existence in the US for a number of years. Processing times of 20, 30 years or whatever it might be, especially for, for example, Indian H-1B holders in the US who want to obtain permanent residence. The processing times for that is, I don't know what the numbers are, but they're crazy high, like 30, 40 years or something. And so what we're seeing now in Canada is it's so weird. It's so weird. It's almost like, once again, the Liberal government is really taking a page out of the US immigration kind of process in with these posting these processing times of, of how many years, 30, 40 years for agencies or whatever it was. I just find that it's just so bizarre for what we've heralded ourselves to be for so many years. And in fairness to the H-1Bers, when they entered this process, the rhetoric, Alicia, it can be considered positive or negative, but it was really heavily around, hey, we want the best and brightest from the US to come here, highly educated tech workers, come here, we've got jobs, you can help to elevate our tech industry and really take us to the next level. That was kind of the messaging that was sent. I'd love to pull up Sean Miller's speech that he gave at the Collision Conference. It was kind of like he was Steve Jobs, it was kind of funny anyways. But so I understand, my heart goes out to the H-1Bers. Now, with that being said, most of the H-1Bers that I worked with never had any intention of coming to Canada. It was kind of a backup in case things didn't work out in the US. And more recently, I've had a number of them book consults and say, now we're ready to move because I've lost my job in the US. The options that I have, my children are reaching the age where they're not going to be able to stay anymore in the US, or whatever the reasons might be, but they're very personal in nature. They're grateful that they have it. And now they can consider this backup. But we have very clear discussions about the fact that the pathways to permanent residence are not what they would have been, 2-3 years ago when the H-1B program was launched. So these are all things that you have to go in with your eyes wide open. And but it doesn't change the fact that I feel for you, Somil. It's a tough situation. You've sacrificed so much to be here in North America, and now it's, there may not be options to stay. So,
And at the same time, I'd like to make it clear, just like Igor had alluded to as well, and Mark, that, permanent residency is the first step, looking for eligibility for permanent residency. There's nothing where you go direct to becoming a citizen, right? And sometimes that terminology may be not very well understood. But it's super important to realize now that things are so competitive that it is up to individuals and families to do absolutely everything that they can to have the best chances to become a permanent resident possible. And it's only if you actually manage to become a permanent resident and you meet your residency obligation and you get your years of time as a permanent resident that you could then potentially apply for citizenship. So you've got to be super strategic on your path.
And right before we wrap this up, I'm just going to pull one more question from Eric, who just became a member of our channel. So thank you, Eric, for supporting whatever we do. So Eric submitted an express entry application under FSW draw, and now they've got the ADR asking for their CV, student form, Schedule A, travel history, and so on. Is it an indicia that they are being put into comprehensive security screening, or they're trying to, pick on something to find an inconsistency in whatever was declared in their application and refuse them?
Yeah.
What do you guys think?
Yeah. Well, anytime an ADR comes, there's a reason for it. They don't just do it for their health. So that's a time to be alert and attentive to everything that's been submitted before. Alicia, they're asking for a brief CV. Well, why would they be asking for a brief CV? There's something previously that they want to double check or cross-reference or see if you're going to say the same thing twice. That might be considered a misrepresentation or an omission. So
Yeah, so Eric, alarm bells go off in all three of our heads as soon as you say this, right? So there's got to be something in a, did you have a study permit? Did you have a PGWP? Are you an in-Canada applicant who claimed Canadian work experience? If not, maybe they're looking at foreign work experience. So if they're looking at your CV, they're looking at what is every single period of work that you claimed? What are those jobs? What are the start dates? What are the end dates? How many hours? Student forms. Did you do studies outside Canada or inside Canada? Because that can matter. It can affect your eligibility to claim Canadian work experience, for example. Schedule A, and travel history. They want to cross-reference where you were when. And depending on how many applicants, maybe this is for you as the principal applicant, but it might be a family member as well. So we would be super worried that they're looking to either refuse your application or worse yet, say misrepresentation and bar you and everybody who's in your family group for 5 years. So please book a consult because this does not sound good.
Yeah, and some of my clients who were sent for comprehensive security screenings also received an ADR asking for their CV and Schedule A's. So it could mean that they intend to send you off to CSIS for an enhanced screening, very possible. And so as we address your second part of the question, how long after acknowledgement of receipt should you wait before you start a Mandamus application? As we've mentioned, each case turns on its own facts. And we typically don't even consider Mandamus unless we see that there is a unreasonable delay that is just egregious, typically three times longer than what it normally takes.
And here's the other big thing about Mandamus. You have to come with clean hands. If you misrepresented, if you fudge something, if you failed to tell immigration something, there is no way a judge is ever going to give you a Mandamus application because it's your fault and you did not come with clean hands.
Right. Yeah. So on this note, guys, I think we can wrap this up and say until next week. So as usual, and let me just pull it up. I'm just going to close this comment. As usual, we will go live again on Wednesday at 10 a.m. Mountain Daylight Time. There's a sponsor to this live Q&A, and this is our Express Entry Accelerator DIY course. You can download the course on our website. Not download, actually subscribe and attend and view the course and attend our masterclass sessions, bi-weekly masterclass sessions on this website, CanadianImmigrationInstitute.com. And if you need and individualized legal advice, and perhaps you need to discuss specific details of your case, we always recommend that you book a consult and get our help as soon as possible.
No, that's actually a good segue into Bree's, Bree Fox's comment there, Igor. I just put it in Facebook as well.
I'm ashamed to pull it up. I'm ashamed to pull it up. I know.
It's,
It's coming. It's coming. It's coming.
yeah. So Bree basically, she just said, it was actually the second part that I wanted to focus on, Igor. It wasn't your citizenship course. So Bree says here in Halifax, not sure if this is on your site, but do you have a citizenship course? So that's yes, we will have this one right away here. Folks, it says, book your consultation. I did for my PR with Mark, and I cannot thank him enough. Well, Bree, you were one of the ones that I'll never forget. So you had a real sticky, kind of challenging situation, and it was a few years ago now that that Bree worked with us, and she was able to get her permanent residence, and she pops in from time to time, and it's really exciting that you're now in a position to be able to apply for citizenship. Ultimately we can help you with that too, Bree. It just comes down to how much or how little support you need. That's what we offer. So yes, but stay tuned for the citizenship course and even citizenship, you guys. We just got a request, follow up from clients. Like I just got a PR card extension application returned because the photo wasn't good enough. This is even after we submitted it through the little tool that assesses it to make sure that it's of high enough caliber. We still got it bounced back. So I have to go figure that out. And then we've got an issue with one of our citizenship applications that we recently submitted. And we're not sure why they are returning it. So understand that these are difficult, dark days of immigration. And absolutely, you need to make sure that you are putting as much effort into these things as you possibly can. It's not like the old days. It's not.
Yeah. Well, thank you, everyone. We see there are a lot of thank you comments in the comment section, so we wanted to thank you, our viewers, as well, and we'll see you next week.